everybody. It's 8:01. I'm actually, for the first time in a long time, we're on time. Said that time 3 times. How you guys doing? It's a lovely Thursday evening here. Wanted to come and give you a little update. We've had a few things happening in different cases across the state, and so I figured I would come and give you guys a little update. And I'll try to answer a few questions if I see them, but sometimes people complain, Tom, you didn't answer my question. Well, their stuff rolls over there so fast, I can't answer them all. So I'll do what I can. You guys, like I had to go in. My son and I were outside doing leaves, and I told Ryan, I said, I got to go get a new T-shirt. So I reached in my drawer and I got one, and I pulled out my Trump shirt. So all you guys that say Tom's a, liberal, or I hear it sometimes, I laugh, or I'm moderate. I voted for Trump in 2016, so I still got it too. It didn't fit for a while, but it fits now. So let's talk about a few things. Let's talk about our Effingham County case first, okay? We still have the restraining order in place. We have a hearing that's still set for May 4th on our issues for discovery, to where we're asking for discovery. They're crying. They don't want to give us discovery. They're trying to say that they're immune. They're immune from having to give us discovery. I gotta sit back a little bit, you guys, so you can really see my Trump 2016. So they're trying to say they're immune. So think of the irony of them saying that they're immune from discovery. They do everything in backdoor deals, because nothing happens on the floor of the House or the Senate, because they do gut and replace legislation that we're complaining of, which means not a damn thing happens so the public can see it, right? And so they do all of that. We file a lawsuit going, we want to see what the hell you were doing. Oh, we don't have to show you that. We're immune from that. And it's like, that's bullshit. Sorry, I'm having a good day today, so I might throw a couple BS words in there, and darn it, I apologize ahead of time. And so we're going to argue that on May 4th. I don't think they're going to be successful, but so be it. But as to our restraining order, it went to the appellate court, and the appellate court upheld our restraining order. Well, then they filed their appeal with the Supreme Court, wanting to ask the Supreme Court to consider the propriety of our restraining order. And the Supreme Court didn't have to take it. And so we filed a response saying that the Supreme Court should ignore this for now. But I was really ready to go fight with the Supreme Court on the restraining order issue, not on the ultimate case, because as you said, you're aware, we're doing discovery. But here last week, they just withdrew the request for the Supreme Court to consider our restraining order. What that means is that as far as our case is concerned, the Supreme Court is not going to take up the issue of the restraining order because the governor and the attorney general asked them to disregard that request. Procedurally, the reason that I think they did that is because they would rather fight in the Calkins matter than fight with us. Okay, I was ready to go fight with them at the Supreme Court on the restraining order issue, and I would have been making the arguments that they don't want to have to deal with, and the Calkins case is a better case for them to make those arguments in. And so they rescinded the request, let's call it, for the Supreme Court to hear your restraining order. So that restraining order is good until something else might change. Okay, that's our case. Let's talk about I've got my list here. So I told you about our case, and let's talk about the federal case going on here in the Southern District of Illinois. Yesterday, there was a hearing, and in that case, you have a few cases that have been consolidated. And I'm really pleased with the level of detail and the legal work, and not even just the legal work, but Todd Vandermeide, who is working with that group, is brilliant when it comes to gun stuff. He's probably better than most lawyers, to be honest with you, and the knowledge he has of the case law across the nation, how it impacts strategy, etc. He is excellent at that. So I talk to him quite often. And I'm following that federal case closely, because that federal case, if it works out correctly, benefits all of us, all of the clients that I represent. It will have a benefit. So I've been watching it, I've been analyzing what they do, to the extent we would ever file something in the federal court, which we can anytime we want to, is only going to be necessary, if something changes. But right now they're doing a great job. I mean, a great job. A couple of the other ones in that, the State Rifle Association, remember the State Rifle Association nonsense where they were out there running their mouth about things? Well, they're in that case too, but they didn't even argue, as I understand it yesterday. They didn't make any arguments in addition to the ones that Mr. Vandermeid's group was making. So great. I'm okay with that. And so they argued yesterday. I heard that the state didn't do a very good job. I heard that they really struggled. I heard that the judge asked a lot of tough questions of the state about their law. And so the plaintiffs in that case were encouraged by, the questions of the court, the way the state struggled in providing any responses to questions. And that's really that Second Amendment argument that they're making in that case under the Bruin analysis is very strong, but it's complicated, and they're doing a great job. Again, at least that one organization's doing a great job, and people of Illinois should appreciate Todd because he's a valuable asset. So how long will it take? And what the judge was considering is a preliminary injunction, similar to what we have in our case. But in the federal courts, if the federal court would issue one, it could have statewide implication. And so the judge took that under advisement, and there's no set time frame of how long it could be from yesterday before the judge might issue a ruling. It could be a few weeks, could be 6 weeks, could be 8 weeks. There's really no way to know. I've been asked that question a lot. And so I can't give you a time frame. All I can tell you is that the judge in the Southern District of Illinois is considering it. And again, we're hopeful that under that Second Amendment theory that was raised in that federal case, that an injunction would issue, and then that matter could proceed through the federal court and eventually get to the United States Supreme Court if it gets that far, unless our state court cases whack this thing down, which is a good chance. We'll get to that in a second. And we'll play that and just see how it goes. I'll keep you guys up to date, okay? Let's talk about the Macon County case, Mr. Dan Calkins' case, as it's called, okay? So that case right now is in front of the Supreme Court of Illinois, and it's being briefed, which means the governor's office submitted their written brief of why they should win. Today is the day that the attorneys for Mr. Calkins will submit their brief. I've not seen it yet. Once I see it and analyze it, we can talk about it a little bit more. But they're going to argue why they should win, okay? And they're dealing with equal protection, as you're aware. And then after they file their what's called response brief today, Mr. Calkins' lawyers, then the state has the opportunity to file what's called a reply. And that reply is due, I have that date, excuse me. Attorney General sent it to me. I asked him for it. April 27th. So by April 27th, the Attorney General's office will have to file a reply, if they choose to, of why Dan Calkins' opinions are wrong. And then there will be an argument, an oral argument in May at the Illinois Supreme Court, and I will be present for that and to go watch and listen. Okay? So that's what's going on. Again, they're dealing only with the equal protection issue on appeal, and you guys we've talked plenty about that. So now let's talk about a few more things with the Supreme Court case, Illinois Supreme Court case. Mr. Calkins' lawyers filed a motion to disqualify or to recuse themselves two of the Supreme Court justices that were just up in the election. Okay, they just won the election in the 2nd and the 3rd appellate districts. I've read their motion that Calkins' lawyers filed. It was well done. It was a good motion. Their arguments are very compelling. And they raise the issues of a couple of things they raise. One, they raise the fact that organizations that were getting money from Governor Pritzker directly or indirectly, or Speaker Welch, went to these two justices, and that creates an appearance of impropriety. One other thing that was argued too is that there's a couple of PACs. You guys know what political action committees are, right? You've heard of PACs and super PACs. These two justices were endorsed by those PACs. And in order to be endorsed by those PACs as a candidate for an office, you have to have taken the position that you will support gun ban regulations. And that in and of itself, the attorneys argued, is a basis for them to recuse themselves voluntarily, or for them to be disqualified because of the appearance of bias, right? They don't argue there's actual bias because, again, that's tough to prove. But the law, and I'm not going to go through the legal analysis, if there's an appearance or it seems that a reasonable person under the circumstances would find that they are not able to be impartial, they're supposed to be disqualified or recused. My opinion is, and I don't give it a lot on these types of issues, sometimes I do, but not often, is, it's a tough call. There certainly is an appearance just as a citizen of the state of Illinois, not even as a lawyer. The appearance is there. I mean, almost 40% of the funding for their campaigns came from Governor Pritzker, Speaker Welch, again, in a funnel. That's tough, right? And the law even says that if you're a judicial candidate, not the law, the rules of professional conduct say that if you are a judicial candidate, and these two justices who were elected were at one time a candidate, it says that you have to be conscious of who is donating money to your campaign, because whether you like it or not, it could subject you to a conflict down the road, even if you didn't intend it. So I don't have to sit here today and say that these two justices are absolutely biased and they couldn't be fair, etc., because that's not even the standard. The standard is whether you, as the public, when you're trying to be able to rely upon your judicial branch to be absolutely objective and impartial, what do you think? That's what's important. How is it seen in the eyes of the people? And everybody that I talk to has a problem with it. Are there people that don't have a problem with it? Probably. You know who they are? They're the people that want the gun ban to be upheld. They don't have a problem with it. So it's human nature. It's really tough. So that motion to disqualify has not been ruled upon yet. The court's going to have to deal with that. How they're going to deal with it, I don't know. But I will say that Mr. Stocks and Mr. Eck, who are the attorneys in that case, did an excellent job preparing that motion to disqualify or recuse. It was well done, okay? Now, in a case like this, you can even do it at any level, but in this Supreme Court case, there is what's called, it's a fancy Latin word, it's called amici, A-M-I-C-I, amici. What an amici curiae is it is a type of document that you can file in a case. You're not a party to the case. You don't get to file motions, you don't get to argue, but you can file this brief and take a position in a case. You can say, I'm asking you to let me file this document because I have an interest in this case. And since I have an interest in this case, I want to make an argument to you in writing. And I want you to accept my argument in writing and consider it in this matter. Make sense? Okay. There's been 2 of them filed in this case now. A few days ago, 33 state's attorneys in the state of Illinois, led by Tom Hain out of Madison County. He was the lead state's attorney, but there were 33 total. You guys, that's damn near a third of the state's attorneys in the state of Illinois. It's unprecedented, for my knowledge. They filed an amici brief. And what they argued is the Second Amendment. I like it. I've read it. It's well done. And it's going to be interesting to see how the Illinois Supreme Court deals with it. And the reason that this matters is because of this. The court in Macon County found this law unconstitutional because of equal protection only. because they followed the accuracy firearms appeal. You're with me, right? And so that's what Calkins took to the Supreme Court with the governor's office, just the issue of equal protection. However, the Supreme Court can find this law unconstitutional on other legal grounds if it chooses to. It doesn't have to find it only unconstitutional for equal protection. It could find it unconstitutional under Second Amendment jurisprudence if it wanted to, or other reasons that I'll get to in a second. And so these 33 states' attorney filed this brief and have asked the Supreme Court. Today was the last day to file one of these types of briefs, okay? And the 33 states' attorneys filed it a week ago. Well done. I've read it, and they do a good job of arguing that the Second Amendment under Illinois law still kicks this thing out. And again, I agree with it. I think it's a good argument. Now, there was another brief filed by us. We filed it today. For those of you that are parties to this case, it'll get emailed to you. It'll also be on the website. I got to jump over here for a second. Somebody's over there putting the Second Amendment, and there's a few people. I see the Second Amendment rolling through here. Guys, let me help you with something. If you think as a citizen of this nation or of this state, you can just start copying and pasting the Constitution of the United States of America or the state of Illinois into your social media, and that means that that's how it's going to be, you are naive and you're sadly mistaken. That document, the United States Constitution, that Illinois Constitution, you burn the damn thing with a match. If you're not going to fight to support it and defend it, that's what matters right here. What are you going to do? You going to fight? Or are you going to get on social media and copy and paste words that are in a document? A document is an idea. It's a concept. It's a way of life. That's all it is. A piece of paper. Like this damn thing right here, guys. So I need you to continue to think about that. If you're not going to live it, even when it's not comfortable, quit preaching about what the document says, guys. It doesn't make any sense. So the brief that we filed, again, even though we're not parties to that case, we have 7,000 plus people in the Effingham County case. That's the identical case. We have an issue. We have an interest in what's going on in that case because the Macon County case, as you guys are aware, it's your case. They just copied and pasted it and filed it in Macon County. We don't need to rehash all of that. But we have an interest in the outcome of that case. And we filed it. And here's what we argued in our case. We also argued, justices, we understand that Calkins is dealing with equal protection. And I threw a little bit of equal protection in there. I couldn't help myself. You guys can read it. But I said, guess what, by the way? Just as the state's attorneys argued that you can find this law unconstitutional for any other legal reason, we are going to say the same thing. And guess what we're arguing in ours? The procedural violations under the 3 readings rule of Article 4, Section 8 of the Illinois Constitution. I bring the whole argument to them on the 3 readings rule. Do they have to follow what I'm arguing for you? No, but I'm damn well going to put it in front of them. And I all but challenge them to take that issue up right now. If they want to deny it, you guys will know that they won't even consider it. But we filed it. It's like, we can still deal with that in our case too. But I'm like, you know what? We're going to put that issue in front of them right now. So they've got the Supreme Court of Illinois has 3 issues in front of it right now against this law. They've got the equal protection. They've got the Second Amendment filed by the state's attorneys, and they've got the procedural 3 readings violation brought by us. That's 3 different shots across the bow at the Supreme Court of Illinois to find this law unconstitutional. Again, that's not the best position for us to be in, the absolute best, but it's best we got right now, okay? And even if none of that's successful, I've also argued that the Supreme Court has to send that case back to Macon County and not just give the governor everything he wants in the Supreme Court. And I don't want to get into those complicated legal analysis. You guys can read it, try to figure it out. But I even had a contingency to our contingency plan, and what I argued in that, trying to make sure that this case doesn't die on a vine in the Illinois Supreme Court long before it should ever die on the vine. So, we've argued and put the 3 readings rule in front of them in the Calkins matter. Calkins didn't want to argue. And I say Calkins, I'm not referring to Dan at the moment. I'm referring to the case. They didn't want to argue it. So we argued it for them through an amici brief. And I'm hopeful that the Supreme Court, again, why would the Supreme Court ignore 7,000 citizens in the state of Illinois who this is their case, right? If you guys are listening or playing, this is your case. Even the Macon County case that's up there right now, it's your case. It's not anything new, just a complete rehashing of your work. Why would they not let you in and listen to what you got to say? I mean, they choose not to if they want, just thumb their nose at you, but we'll see how that goes. So that's what's going on in everything. I don't think I had anything else to go over. If there's any questions, I'll try to look. No, you can't get the governor removed from office. It's 99.99999% impossible. So not going to happen. No, you can't join the case, guys. I get emails all day long. We started that back in when? January? No, we're not. There's no zero chance of anybody joining any cases at this point. Oh, there's the Illinois Rifle Association. I got to do that. I can assure you that Todd is not talking on behalf of the Illinois State Rifle Association. So no, he's talking on behalf of Todd and the people that groups he's affiliated with. Todd is not speaking for the State Rifle Association. State Rifle Association finally got smart enough they just need to quit talking is what they needed to do. And so somebody probably gave them good advice, just said, be quiet. Ryan, you see anything? It wasn't breaking. Somebody said it's breaking up every word. It wasn't breaking up every word, was it, Ryan? You didn't say anything. I don't think there's anything there. I don't see anything. Anybody got anything else we need to cover? Somebody says, what happens to our case if the federal case wins? It depends. Again, that's so complicated, but that federal case is not going to be over. Federal cases are slow. A federal case will be continuing long after we are resolving our state court cases. That's why we started in the state court, because it was effective and it could end all of this a whole lot quicker than a federal case. I guarantee you guys with 100% certainty, Governor Pritzker and the Illinois legislature did not see us coming in the state court. They didn't see it coming. They had no expectation that that was going to happen. They thought that this case that the gun dispute would end up in the federal court and it would languish for a long time and drag on for years, 2-3 years. And by that time, Governor Pritzker had already got his name ID up because he was fighting the good gun fight and running for president. He never saw a smacking coming in the Illinois courts. It would happen a lot quicker. It caught him off guard. I guarantee you they didn't see that coming. I think it's funny. The Illinois Supreme Court cannot choose to not follow Illinois or United States Supreme Court decisions on issues that are federal, right? But if the only thing you can do is if they try to get around a United States Supreme Court decision is go to the United States Supreme Court and get them to tell the Illinois Supreme Court you can't do that. As of yet, the Illinois Supreme Court has not issued a decision contrary to the United States Supreme Court decision in Bruin or otherwise. So again, that's speculation at this point, but the answer is they can't on an issue that's federal in nature. Somebody's asking about FFLs that aren't in the case. I'm not going to say what they can do and can't do. They do what they want. I mean, I don't represent them. Whether they think they can sell to one of you that's on the TRO or not, that's none of my business. They can do whatever they want to do. I mean, people are getting on late and they're asking questions that I've already answered 2 or 3 times. You guys can go back and watch it. There's no the motion to dismiss in our case. It's not a big deal. It has to do with the 3 readings rule issue. It's a procedural nothing burger. So, I mean, the 3 readings rule is never going to win in the trial court level. We already know that. So that motion to dismiss, it's just procedural and has to do with the 3 readings rule. That's all. Yeah, somebody said something about us starting an organization for gun rights, and even I was going to do gun rights and parents' rights, similar to like what the State Rifle Association does for gun rights. There's really no statewide organization on parents' rights. Shannon Adcock does a good job up in her part of the world, but there's nothing statewide. We're still trying to work on that, but keep in mind, we got a lot of irons in the fire right now dealing with this stuff. So yeah, it's still a conversation, but even if we started that organization today, it's not going to be able to be involved in this particular issue we're dealing with at the moment. We've already got that handled. So, but yeah, that's still a conversation. Okay. All right. I think that's it. Joe, I'm not, if somebody asks, well, what if discovery is denied? What's the time frame for us? Again, I'll find out about that on May 4th. I have no expectation that discovery is going to be denied, because if discovery was going to be denied, judge would have done something different 2 weeks ago. So is it possible? Of course it's possible, but I don't sit here and speculate about things I don't think are likely like that, because otherwise it doesn't get me anywhere. I won't know the answer to that until May. Okay, guys. You can't get your name on the TRO. It keeps bouncing. 100% impossible. You can't get on the injunction ever. It's impossible. Go hire a lawyer if you want to and have him file a new case on your behalf. And you probably would get one from a court, because they'd have to follow the laws that exist today. But I'm not going to do that anymore. It doesn't help my clients that I have right now. It just complicates the issue. So we don't have any ability, desire, interest in doing any of that, you guys. Somebody else has to do that. I don't think about the second group on the, I don't understand, Scott, is the second group on the TRO. There's 4 groups on the TRO. They've always been on it. They've been on it for, I don't know how long it's been, Ryan, several months now, 1, 2, 3, 4 months. Scott, all 4 groups are on it. So hope that answers your question. What happens to the rest of the FOID people? Till the law's overturned, they're shit out of luck. That's what happens to the rest of the FOID people. They can't go buy a defined assault rifle. I can't help that. I mean, they had the same opportunity everybody else did for months to participate, and I'm sorry, we couldn't get everybody on it. So yeah, I'm not going to sit here and sugarcoat it for you guys. FOID card holders are not a part of this injunction right now. Can't go buy them, and I can't. I'm on that list, so I'm not giving people crap that I'm trying to make a mockery of. I'm not on this TRO. 7,000 clients. I'm not going to put my own name on there. I can't go buy one either. I'm in the same boat. And, you know, could I go file a case on my own behalf and do it? Yeah, I could, but I've not done that. So again, I'm in the same boat as the rest of you FOID holders that aren't on this injunction. So. People over there saying, what does this case mean for us if I'm on the case and in the injunction? Again, I would hope that if you're on, and I don't know that the person that said that is actually a plaintiff in this case, but if you're a named plaintiff in this case and you haven't been keeping up with what's going on and you haven't been reading any of the, I don't know how many emails that Ryan sends, guys, what do you want me to say? I don't know. Send an email to Ryan and have him forward you the 80 emails he sent in the last 4 months and read through them. I mean, I seriously can't sit here and respond, you know, give everybody everything of what it means since day one that we filed this case. Again, if you're on this case, guys, I hope that you're paying attention. I really do. But if you're not, I've done everything in my power to deal with that. Look at Sandra over there. I gotta love her. I'm keeping up and I'm not even on the list. Yeah, and right, and all the documents that somebody who said that over there, is that Mandy? All the documents are on the website. Yeah, go get every document you want on our website. I should say Ryan has done everything in his technological ability to give this stuff to people in as easy a format as they can get it, right? And it's still, he pulls his hair out a lot of days answering the same question 500 times sometimes. And it's like he has to copy and paste the same answer going, I sent that out like the last, 10 times and go here and get it. And they're like, oh, okay. It's like, it's really hard to manage that many relationships, guys. And that's, again, we signed up for it. We're okay with it. But just if you're on this case, do a little bit of due diligence for yourself. Go check your email. If it's not in there, look in your spam. If it's not in there, go to the website. Every document's there. They're easy to pull up. They're accessible. If you still got a question, you send an email, but do a little check-in first before you just send in. How many emails Ryan gets a day going, I've never got anything, and I don't know why you're not sending me anything. And Ryan will respond back to them and show them where they got the last 20 emails and they just didn't go find them. And it's like, poor guy. I'm trying to defend Ryan because he insulates me from most of that, but it's like, oh my God. All right, I'm going to go, and you guys have a good night. We all got day jobs, whoever said that over here. Just wanted to make sure you didn't have any more questions that I needed to answer. Have a good night.